Every single day, businesses lose an estimated $600 billion globally because of stolen ideas, copied products, and intellectual property theft. $600 billion. That is not a rounding error. That is an economy larger than most countries on Earth, quietly evaporating because creators, inventors, and entrepreneurs did not understand how to protect what they built. And here is the part that will keep you up at night. Most of those losses were completely preventable. Welcome to Legal Eagle Brief. Today we are breaking down intellectual property law in a way that actually makes sense. No law school jargon. No confusing Latin phrases. Just the real framework you need to understand how ideas become protected assets, why some creators walk away with millions while others watch their work get stolen in broad daylight, and the one category of IP protection that most small business owners completely ignore until it is far too late to fix the problem. By the end of this video, you will know exactly what intellectual property law covers, how each type of protection works, and what steps matter most when real money is on the line. Stay with us, because the counterintuitive insight we get to in the second half of this video has changed the way thousands of creators think about their work. Let us start at the beginning. Intellectual property law is essentially the legal system built around the idea that your mind can produce something valuable, and that value deserves protection just like physical property does. If someone steals your car, the law steps in. If someone steals your song, your logo, your invention, or your secret formula, intellectual property law is what steps in instead. The concept is not new. The first formal patent system dates back to Venice in 1474. The Venetian statute offered a 10-year exclusive right to anyone who created a new and useful device. The logic was straightforward. If you reward innovation, you get more innovation. That same logic is baked into every modern intellectual property framework around the world today, including the United States Constitution, which explicitly gives Congress the power to promote the progress of science and useful arts by securing rights to inventors and authors. There are four main pillars of intellectual property law: copyrights, patents, trademarks, and trade secrets. Each one protects something different. Each one works differently. And confusing them is one of the most expensive mistakes a creator or business owner can make. Let us start with copyright, because it is the most misunderstood of the four. Copyright protects original works of authorship. That includes books, music, films, artwork, software code, architecture, and even certain website content. Here is what most people do not know. Copyright protection is automatic. The moment you create an original work and fix it in a tangible form, meaning you write it down, record it, or save it, you own the copyright. You do not need to register. You do not need to put a copyright symbol on it. The protection exists from the moment of creation. But here is what nobody talks about. Automatic protection and enforceable protection are two very different things. If you want to sue someone for copyright infringement in federal court, you need a registered copyright. Registration gives you access to statutory damages, which can run up to $150,000 per infringement, plus attorney fees. Without registration, you are limited to proving your actual losses, which is an incredibly difficult and expensive process. The United States Copyright Office charges as little as $45 to register a work. That is one of the most underutilized legal tools in existence. Copyright protection lasts for the lifetime of the creator plus 70 years. For works made for hire, meaning work created by an employee within the scope of their job, the term is 95 years from publication or 120 years from creation, whichever comes first. Now let us talk about patents, which protect inventions and new processes. There are three types: utility patents, design patents, and plant patents. Utility patents are by far the most common, covering new and useful processes, machines, manufactured items, and compositions of matter. Design patents protect the ornamental appearance of a functional item. Plant patents cover newly discovered asexually reproduced plants, which matters enormously in agriculture and biotechnology. Here is a number that puts patents in perspective. In 2023, the United States Patent and Trademark Office granted over 320,000 utility patents in a single year. That is nearly 900 patents approved every single day. But securing a patent is not easy. The process typically takes 2 to 3 years, sometimes longer. The average cost for a utility patent, including attorney fees, runs between $10,000 and $30,000. And not everything qualifies. Abstract ideas, laws of nature, and natural phenomena are not patentable. That is why software patents have been one of the most contested areas of intellectual property law for the past 2 decades. Utility patents last 20 years from the filing date. Design patents last 15 years. After those terms expire, the invention enters the public domain, meaning anyone can use it freely. That is by design. The system gives you a temporary monopoly in exchange for full public disclosure of how your invention works. Trademarks are the third pillar, and they work completely differently from both copyright and patents. A trademark protects words, names, symbols, logos, and slogans that identify the source of goods or services. The Nike swoosh is a trademark. The McDonald's golden arches are a trademark. The phrase "just do it" is a registered trademark. Unlike patents, trademarks do not expire as long as they remain in use, and you continue to renew them every 10 years with the USPTO. That is why Coca-Cola has been protecting its trademark since 1893. That is 130 years of continuous trademark rights on a single brand name, and there is no end date in sight. But here is a critical concept called trademark dilution. If a trademark becomes too generic through widespread misuse, it can actually lose protection entirely. Aspirin was once a trademark owned by Bayer. So was escalator. Thermos. Even yo-yo was once a trademarked brand name. When the public starts using a trademark as the generic word for an entire product category, courts can cancel the trademark through a process called generic-ide. This is why Google, Xerox, and Kleenex spend significant legal resources reminding the public that their brands are not generic words. The fourth pillar is trade secrets, and this is the one that deserves far more attention than it usually gets. A trade secret is any confidential business information that gives a company a competitive advantage. The classic example is the Coca-Cola formula. It has never been patented, deliberately, because patents expire and require public disclosure. Instead, the formula has been kept as a trade secret for over a century. Trade secret protection has no time limit as long as the information remains confidential. But that is also the vulnerability. The moment reasonable steps to protect confidentiality are not taken, protection can be lost. Courts look at whether a company used non-disclosure agreements, restricted access to sensitive information, trained employees on confidentiality obligations, and implemented security measures to keep the information private. Under the Federal Defend Trade Secrets Act of 2016, companies can sue in federal court for trade secret misappropriation. Damages can include lost profits, unjust enrichment, and in cases of willful and malicious theft, courts can award double damages plus attorney fees. Now for the real-world analysis that ties all of this together. The most successful companies treat intellectual property as a strategic asset, not an afterthought. Apple holds over 70,000 active patents. Amazon filed more than 2,000 patent applications in 2023 alone. These companies do not just build products. They build IP portfolios that create competitive moats. Competitors cannot easily cross. For individual creators and small businesses, the practical lesson is this. Copyright your creative works and register them. Trademark your brand before someone else does, because trademark rights in the United States go to the first to use in commerce, not the first to file. Evaluate whether your innovation qualifies for patent protection before you go public with it, because public disclosure before filing can kill your patent rights entirely. And use non-disclosure agreements and confidentiality policies to protect your trade secrets from day one. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.